This video explains the 7 stages of an appellate special action at the Arizona Court of Appeals, Division 1. An appellate special action starts when a petition for special action is filed at the Court of Appeals. The petition should say why you think the Superior Court was wrong and why you believe the Court of Appeals should act now instead of waiting until the end of the Superior Court case. In the petition, tell the court why it should accept special action jurisdiction. Watch the video called Things to Know About Appellate Special Actions to learn more about the factors the court will consider when making this decision. Also include the legal issues you want the court to review, key facts related to the issues, pointing to specific parts of the case record, any laws, cases, or court rules that support your request, the name and case number of any related appeal, special action, or petition for review. You can file the petition in paper by mailing or bringing it to the court. If you do that, be sure to give the court both the original and one copy. If you want to e-file your petition, use Turbo Court. No matter how you file, you must give a copy of the petition to the other party and to the judge whose decision you are challenging. Watch the video called Things to Know About Service to learn more. Do not forget to keep a copy of the petition for yourself. There are several documents that must be filed with the petition. The first is an appendix that has a copy of the decision you are challenging and any important documents from the Superior Court. If you discuss something from the Superior Court record in your petition, you must put that document in the appendix. The Court of Appeals cannot see Superior Court documents unless they are in the appendix. In addition, file a contact sheet with party and attorney information, a cover sheet with information about the Superior Court case, a certificate of compliance showing the petition is not more than 10,500 words, and a certificate of service explaining how you served the petition on the other party and on the judge whose decision you are challenging. Forms for these documents are available on the court's website. When you file your petition, you can also file these optional documents. Transcripts of Superior Court hearings. A transcript is a typed copy of everything that was said in a hearing. If your appellate special action is about things that were said in a hearing, you may want to file a transcript with the petition. Otherwise, the Court of Appeals may assume that what was said supports the Superior Court's ruling. If you want to file a transcript, contact the Superior Court as soon as possible to find out how to order one. A stay request if you want the Court of Appeals to pause the Superior Court's ruling or other proceedings during the appellate special action. Watch the video called Stays in Appellate Special Actions for more information. A request for oral argument if you want to ask the Court of Appeals to let you and the other party talk to the judges in person about the appellate special action. A form is available on the court's website. Be sure you serve these documents on the other party and on the judge whose decision you are challenging. When you file the petition for appellate special action, you must pay a $330 filing fee. The court cannot refund the fee or apply it to another case, no matter how the special action turns out. You can pay the filing fee by mail, in person, at the Court of Appeals clerk's office, or online through Turbo Court using a debit or credit card. If you cannot afford the filing fee, you can ask the court to waive or defer your payment using the application for deferral or waiver of court fees available on the court's website. The court will not review your petition until the filing fee is paid, waived, or deferred. The Court of Appeals will notify you when it opens the special action and assigns a case number. You must use the case number when you file documents or contact the court. The court will tell you the names of the 3 judges assigned to your case. You can also check the docket on the court's website to get case information. The Court of Appeals does not have to accept an appellate special action. It will review the petition and appendix and determine whether it wants to decide the issues raised in the petition. The video called Things to Know About Appellate Special Actions explains the things the court will look at to make this decision. If the judges decide not to take the case, they will decline jurisdiction in a summary order, and the special action ends. Or the judges may allow the other party to respond to the petition. Allowing a response just means the court will consider both sides, not that it will accept jurisdiction or agree with the petition. If you ask the Court of Appeals to stay the Superior Court's ruling or proceedings during the appellate special action, it may hold a hearing on that request. If the court orders a response to your petition, the other party can argue that the Superior Court was right, or that the Court of Appeals should not take the case. They can also file an appendix with additional documents from the Superior Court. The court may let you file a reply to respond to the other side. If so, it must be 5,250 words or less, and you cannot add new arguments that were not in the petition. The court will not consider the reply unless it gets it by the due date. Mailing it before the deadline is not enough. Do not forget to serve the reply on the other party and the Superior Court judge. After you file a reply, or the deadline passes, the judges will meet to discuss the appellate special action at a conference. You cannot attend the conference. The judges usually decide appellate special actions by reading the petition, the response, and the reply, and by looking at the appendices, without setting oral argument. If the court schedules oral argument in your case, the court will tell you when and where to go for the argument. Arguments are usually in person at the Court of Appeals building in Phoenix. A case is under advisement after the judges discuss it at the conference or hear oral argument. During this time, the judges research and write their decision. It may take several weeks for the judges to decide a case once it is under advisement. You will get a written decision when the judges decide your case. If the court declines jurisdiction, the decision will be a short order. Otherwise, the decision will explain the judge's reasoning and the outcome. It will be sent by mail or email, if you chose email delivery, on the release day. All decisions are public and posted on the court's website the day they are released. We hope this video makes it easier to manage your case. For more information, visit the court's website or contact the court.